Hello, everybody. I'm Catherine London. I'm an attorney in the Health Law Group at Frederickson and Byron, and I have the pleasure of introducing our two webinar speakers today. First, a couple housekeeping issues. Wanted to let everyone know that the webinar next month will be on Wednesday, November 11th at noon, and Katie Douglas and Ryan Johnson from the Health Law Group will be talking about anatomy of a healthcare transaction. So it should be a great topic, and we hope you can join us for that. If you have any sound issues, feel free to use the dial-in number, and also to ask questions throughout the webinar, you can just use the chat box on your screen, and the presenters will be able to hear or answer those questions. And remember that the webinar will be available for free on our SlideShare site after it's over, so feel free to check out our old webinars or this webinar on our SlideShare site at your convenience. So today we have Bob Aronson and Deborah Schneider from the Immigration Group at Frederickson and Byron who will be presenting on a very important issue that's increasingly relevant, and that's making immigration work for physician recruitment and retention. So I will turn it over to Bob and Deborah, although I know Deborah's having a little difficulty today, having lost her voice, so apologies if you have any trouble hearing, but she will certainly do her best. So now take it away.
Okay. Well, thanks very much. This is Bob Aronson. I have a great deal of pleasure in presenting this program, or co-presenting with my colleague Deborah Schneider, who is laboring under some difficulties with her voice, as you will soon discover. But what we want to do in this program is really to talk about immigration from the employer standpoint, and not only from the employer standpoint, but trying to provide some ideas, some guidance on how immigration can actually be used as a competitive advantage in your recruitment program. So we are going to be talking about immigration law, but we want to do it through a prism of recruitment, making it into a proactive, productive element of your recruitment efforts to be able to expand the pool of candidates who will be working within your system. So we want to talk about really how do you make recruitment and immigration work together. We have two objectives to this program, two measly objectives. First of all, within this hour, we want to talk about some ideas just to skill build, to increase the ability of employers, of recruiters, to consider international applicants for physician positions within your system. So some of it is going to be skill building. But the second issue for discussion, and hopefully this can also elicit some input from the audience, is how do you make immigration work competitively for you in terms of increasing your ability to recruit and attract international candidates. Before starting, I just want to make two basic comments. First of all, we want to talk a little bit about what's going on in healthcare staffing in general, and then where does immigration fit in. As you know, the basic situation is that the physician workforce is getting stretched more and more, and it's getting more and more difficult to attract candidates to fill physician positions. So you have a growing and pervasive shortage of physicians. So what is that doing? First of all, there's a greater emphasis today on finding non-traditional provider sources. So those non-traditional provider sources can either be from allied healthcare professionals who more and more are being licensed and certified to expand the scope of the services they provide to patients, or it can also be sourced from non-traditional sources of physicians. And that's where this whole notion of international physician recruitment comes in. one of the non-traditional sources of to provide physicians to healthcare systems. Here's where what you also need to be aware of, and that is that the foundations of immigration law, as applied to physicians, date back to 1978. There was a law, the Health Professional Education Assistance Act, which was premised on two basic assumptions. Assumption number one is that there is a shortage, there's an overabundance of physicians in the United States, and therefore immigration should be quite restrictive to physicians. And coming out of that, by the way, you have the two-year home residence obligation, credentialing requirements, and so on. The second underlying policy consideration to this 1978 law was that foreign physicians have inferior substantive, cultural, and linguistic skills. So what you have is the rudiments, the foundations of immigration law being premised on public policy which may not be in existence today. That is, as opposed to having an overabundance of physicians, the current contemporary situation is that there's a shortage of physicians. And international physicians can be one of the useful provider sources to decrease that shortage. So what you've had over the last 40 years, basically, are various incremental steps to chip away at the restrictions in immigration law for physicians. And that's kind of what we want to focus on how you can take the basic resistance in immigration law, which makes it somewhat difficult, and yet it is still possible to navigate this entire system and to make it part of your recruitment efforts. Okay, simply as a foundational statement, what we're talking about is international medical graduates, by definition being physicians who have received their medical education abroad. So that could be a U.S. citizen, it could be a U.S. permanent resident, it could be a foreign national. So what we are going to be focusing on a subset of international medical graduates, a subset of IMGs, who are foreign nationals who require visa coverage. So what you've got in this whole system are two things at play. Number one, the need of IMGs, for our purposes, that's foreign national IMGs, to get appropriate immigration coverage, number one. And number two, the need of IMGs, who could be either foreign national or domestic IMGs, to meet the credentialing requirements in order to practice medicine in the United States. Okay. One of the basic issues becomes, why even consider IMGs? Why even consider international physicians in your recruitment program? Well, we've talked a little bit, and as you well know, about the shortages in the physician workforce. They're pervasive. They spill over from simply economic or geographic pockets. It is a pervasive situation which is predicted only to grow in its severity in the future. But in addition, immigration has an implicit, an inherent ability to steer international physicians into hard-to-fill positions or into positions that putatively benefit the national interest. So our immigration laws tend to steer physicians into certain geographic placements, perhaps rural or isolated practice situations, into certain practice specialties that may not be adequately represented, and above all, into positions in which there's a strong safety net component. So given that, you have an immediate union of positions that are hard to fill and immigration laws that tend to encourage physicians to take these hard-to-fill positions. And as a result, you can really, in many instances, get highly qualified applicants who need visa coverage in order to staff hard-to-fill positions. So that's what we want to talk about. And in addition, you've got implicit in the visa system, you have the reality that once a physician gets certain types of visas, they may have obligations to continue to work with the sponsoring employer. So there's a certain retention element as well. Okay, let's talk though about some of the disincentives to IMG recruitment. Some of them I feel are legitimate, some not. Certainly one of the disincentives will be the time involved and the expense of working with an attorney, going through filing fees, and so on. I do need to say that probably one of the disincentives is also the need to work with attorneys. That it's not an easy statement to make, but it's probably nevertheless true. You also have a disincentive with concerns about our IMGs, our foreign national IMGs, culturally and linguistically suitable for employment in the United States. The test data, particularly over the past decade or so, indicates that they are culturally and linguistically, as well as substantively commensurate with their U.S. counterparts, but it's certainly a recurrent concern. There's also a great deal of concern that once you sponsor an IMG and qualify them for a visa and go through the time and expense and disruption, that they skip out on you once they get permanent residence or once they get visa status. Obviously, that's of concern, like it would be for any physician provider within a system. I will say that the last study by the Congressional Budget Office indicated a great deal of retention of IMGs with their sponsoring employers. So empirically, it's not quite tested out or quite validated. And above all, there's this idea of complexity of the immigration process. So one of the issues concerns, what do you do when considering an IMG candidate? And again, this is starting to move into how do you increase your recruitment profile. One of the things that I really strongly suggest, that Deborah and I very strongly suggest, is get Immigration Counsel involved in the recruitment process early in this cycle. And here's how it should work. As you identify candidates, it makes a great deal of sense on multiple levels to get Immigration Counsel early in the recruitment cycle speaking with your candidate. And it has really three basic purposes. Number one, simply to do an assessment early in the recruitment cycle in terms of what is the likelihood of success, what are the issues, what's the timeline, and so on. But number two, and extraordinarily importantly, is that the mere dialogue between Immigration Counsel and the physician indicates a certain awareness of the employing entity and a certain commitment of the employing entity to the immigration welfare of the foreign IMG. And then the third issue, which is something we rigorously uphold, is that at the conclusion of the discussion, counsel should really put in writing to the employer, to the IMG, the synopsis of the discussion to create a level of transparency, to create a level of trust, and really to get the issues on the table. And then basically, look, Immigration Counsel bows out as the recruitment takes its course. If the recruitment is successful, then Immigration Counsel will get re-involved. But the point is that bringing Immigration Counsel in early in the process is an excellent way of communicating something very meaningful to the foreign candidate, which is that the employer is committed to the immigration welfare of the physician. So in terms of how do you create a recruitment program that gives you this competitive edge, well, I think that it really starts by understanding the objectives of the IMG. What are they? There are two things. Number one, to get a good job. I mean, what physician doesn't want that as a result of substantial periods of training and education? But secondly, the IMG, the foreign IMG, is going to be very concerned about immigration welfare, both short-term and long-term prospects. So get those out on the table. I think it's very good for employers to have a transparent policy. When do they start the permanent resident process? What are the conditions? What is the established policies of an employer when it comes to immigration? It's this whole idea of demystifying the immigration and the permanent resident process. One of the things in terms of fostering retention, particularly in rural communities, but actually it's broader than that, is to pay some attention to spousal issues. That is, the IMG is going to be working, they have employment authorization, they have a good professional career under development, but there's oftentimes a significant disparity between the level of satisfaction of the IMG, the principal applicant, and the spouse, who may, in his or her own right, have significant professional capabilities, but is stymied from working and developing a career in the United States. So be aware of that, and there are certain procedures, there are certain things in immigration law that can address and foster the satisfaction of the spouse as you go through the immigration process. Okay, those are simply some basic foundational thoughts in terms of constructing a proactive, IMG-oriented and focused and sensitive immigration process. What we want to do over the next period of time is to review somewhat briefly, but the three paradigms of IMG immigration. That is the J1 Exchange Visitor Program and the Waiver Program. Number two, H1B employment issues. And then we're going to wrap things up with a couple words about permanent residence. So, testing the winds with Deborah's malady with her voice, I'd like to turn things over to start the discussion on J1 Exchange visitor issues and what that entails in terms of recruiting a J1 physician.
Thank you, Bob. So I do apologize from the beginning. I woke up this morning with a terrible cold, which has hijacked my voice. So I'll do my best to speak up so you can hear me. So where it comes down to a J1 visitor is this is most likely how you're going to meet an IMG physician. And what this means is this is going to be how the type of visa that the doctor used to come to the U.S. to continue their medical education, most likely during their residency. And this ties into the earlier law regarding what restrictions they're putting on doctors. And this is because the J1 program is administered by the Department of State. And when you have the Department of State involved, this brings into an exchange program. And so the goal of the program is to introduce to the doctor ability to advance their career, their education in medicine, but the hope is for them to then return to their home country and provide these skills back home. And because of this, this provides a restriction on the doctor's ability to work in the U.S. for you. So with this, the doctor who's on a J1 can be on a J1 program for up to 7 years, which is usually enough to continue a residency. But this 2-year home resident obligation is what makes it more complicated when hiring a physician. And this is because of, we call it INA 212E, that's just the statute it falls under, which says if you've conducted your medical education in the United States, you need to return to your home country for 2 years, and then you're free to come back to the U.S. to work for a U.S. employer. So what restrictions have they put on the doctor? They've said you can't switch to a work visa, such as an H1B, and you can't adjust status to become a permanent resident until you meet this 2-year home obligation. And so part of the question is, where do you as an employer fit in? Most likely recruiters are going to come to you with what looks like an exceptional candidate, and you ask, how can I employ them? And you say they're a J1 physician. What this means to you is you're going to have restrictions on your ability to hire this physician unless they qualify for an H1B, which would likely require them to first get a waiver, or in some certain circumstances they could request an O1 visa. And why an O1 is an option is when they made the regulations that prevents J1 physicians from changing status to a work visa, the O1 got left off. So we've exploited this opportunity for a poor drafting regulation to use O1s. And this is going to be not for every doctor. This is going to be for those who we considered exceptional or at the top of their field. So this is really going to be candidates who within their residency have had significant publications, significant research, potentially served on high-level panels. It's going to take the right physician to have this fit, but it's definitely worth exploring at the front end of your recruitment. We often ask, why don't you send us their CV? We'll take a look at it. Often there's a good possibility this could be an ability for you to hire the doctor. The other option is to have the physician seek a waiver. I had planned to go through this in detail, but I may turn this over to Bob so you don't have to continue hearing my voice. But I can generally note that there's three main areas that you can seek a waiver. One is the doctor themselves can qualify for a waiver by showing exceptional hardship to an anchor relative. Who is this anchor relative? Well, this would be that they're married to a U.S. citizen or permanent resident spouse, or have a permanent resident or U.S. citizen child in the U.S. The standard is fairly high. They're going to expect that if you married someone while you were here in the U.S. as a resident, they already understood that you had a 2-year home residence requirement. So the marriage alone or having a child in the U.S. is not enough to meet the standard, but it's going to be very case specific. It could be that the individual you've married is from a different religious faith or cultural background and could have disruptions if they move to their home country. They could have their own career that could be disruptive. So it's a very personal factors that we'd want to evaluate on why they can't return home. For many physicians, they could have a fear of persecution. This has become much more relative with what we see going on in Syria and Egypt and many war-torn regions where it would be very dangerous for the physician to return at this time. But the most likely avenue you're going to pursue is going to be sponsorship by a government agency. And I'll let Bob give you more information about that topic.
Okay, Bob, he who has the healthy voice, but Deborah, you really, it's almost courageous how you've done things, so thanks very much. Look, let's start off. We're talking about waivers based on government agency sponsorship. That's what we're going to be talking about for the next couple of minutes. And the underlying theme is there are going to be certain situations where an IMG is going to be doing work that is so meritorious as to lead a government agency to intervene and override the need to go back to the home country. And in the law, this gets all lumped under a concept of that the IMG will be serving the public interest to such an extent that a government agency becomes interested in the ongoing employment and residence of the physician. So the point becomes, what types of situations exist that would lead a government agency to intervene and override the 2-year home residence obligation? Well, basically, there are 4 paradigm situations in which a government agency will intervene. The first, which I just want to get on the table, is the physician scientist. So a physician scientist doing cutting-edge work of national significance, the employer of that physician could file a waiver to the Department of Health and Human Services, essentially to the NIH, saying, will you override the need to go back to the home country because this physician is doing such meritorious, cutting-edge research work that accrues to the national interest of the United States. So that would be paradigm number 1. Paradigm number 2 would be if a government agency directly employs the physician in the furtherance of that agency's interests, that agency would sponsor the physician. So the most common one numerically would be the VA, which hires physicians and therefore sponsors physicians as a matter benefiting its own interests. Also, it would be the Army or any other federal agency. The third paradigmatic situation for a government sponsor would be various federal agencies. So there are a number of federal agencies that do sponsor physicians for waivers of their home residence obligation. There is one national agency, which is the Department of Health and Human Services, that has a pretty restrictive waiver program. It's limited only to primary care physicians. And then there's a number of regional agencies, such as the Appalachian Regional Commission, the Delta Regional Agency, and so on, that for limited geographic areas will sponsor physicians. But the fourth waiver, the fourth situation for waiver sponsorship is the one we want to talk about, and that is something called the Conrad Waiver Program. And I know that many or most of you are probably quite familiar with this. This is a program which only dates back to 1994. It's not that old, all things considered, in which the states have the right to sponsor a limited number, a numerically limited number of physicians for waivers. The way you need to think about the Conrad program is it is a federal-state partnership. So what do I mean by that? The federal government or the Congress enacted a law signed by the president that lays out certain parameters as to when states can sponsor waivers. What the federal legislation does is it says that each state Department of Health can sponsor up to 30 waivers each fiscal year for physicians who are essentially expanding the safety net, who are doing meritorious work largely targeted to the indigent and the medically underserved. Of that 30 waiver allotment, 10 waivers can be used in non-medically underserved placements. So the state has flexibility to recognize that a physician may be expanding the safety net even if the physician is not physically working in a designated medically underserved area. The balance of numbers, which would be 20 numbers or 30 or up to 30 numbers if the state does not use its flex authority, can only be used for physicians working in designated medically underserved areas. The program opens every October 1, so this webinar is actually taking place at a very propitious time. Each state got 30 waiver numbers just over 2 weeks ago. So starting October 1, applications come in and states draw down on their numbers. But as a general observation, most states will still have waiver numbers available within their systems. They haven't used up all of their 30 waiver numbers. Just to dispel one misapprehension about this program, you can get a waiver under the federal program for either a primary care physician or a specialty care physician. Now, within the contours of the federally enacted program, each state can enact its own rules, again, working within those parameters. So some states will have non-compete clauses. Some states will have special application provisions. Some states, in their discretion, can limit waivers solely to primary care physicians. Some states can have liquidated damages provisions. Whatever those, there's a list of things that need to be checked out state by state by state. But again, all of the state provisions need to work within the parameters of the federal legislation. So when considering placement, one of the things is to check out the individual state provisions, and it is usually extremely productive to place a call to the state waiver officer, who not only knows in many instances, the local situation within the communities, but can really provide a good synopsis of any special issues, of any changes in rules and regulations, and most importantly, on waiver number utilization. So this really gets into a real team effort in terms of Immigration Counsel interfacing with the state waiver officer, with the interfacing with the employer, the community, and so on. But that's really how kind of a waiver is developed. And again, I want to say that even though that we have 50 states, each of which has its own, waiver rules, the underlying issue that needs to be established, and this is really the golden thread running through every waiver we've ever done, is how can you show that the physician will meet the state's objectives of expanding the safety net to medically vulnerable patient populations. And so then you get into things like, what is the charity care policy? What is the provision to public assistance patients? What are the bona fides, the merits, the social commitment of the employer to serving broader patient needs within the state? That is really kind of when all is said and done, that's the whole purpose of the Conrad program. Well, what does the Conrad program do? Or what does waivers in general do? What a waiver does is it simply removes an impediment to staying in the United States. It means that the physician does not need to return to his or her home country. But it does not create any affirmative basis to stay in the United States. So what the law says is that if you get a waiver, if a physician gets a waiver, then the physician has an obligation to work for 3 years, specifically in H1B status, for the sponsoring employer. So here you have a certain retention obligation that is built into the acquisition of the waiver. The waiver is issued. The employer then needs to sponsor the physician for a change into H1B status. The physician absolutely needs to work for 3 years in H1B status with the waiver sponsor in order to fulfill a key term of the waiver. If the physician does not fulfill this 3-year H1B obligation, they have violated a major provision of the J1 waiver in a manner that will subject them to removal or deportation and render them ineligible for permanent resident status. There's a very limited situation, largely related to employer abuse or exceptional hardship, that would let a physician skip out within that 3-year period of time. But those are relatively rarely encountered, and the U.S. immigration authorities are actually quite skeptical and resistant to breaking off employment within the 3 years. So again, you get the waiver, you've got to get into the H1B, you have to work for 3 years in the H1B. That has a certain retention element. Let me go. Yeah. Okay, we're going to move into the H1B temporary worker classification. And I just want to, again, say that I'm pinch hitting for Deborah, and Deborah's been the co-creator of this program, but I'm going to continue talking, which is maybe one of my strong suits. Want to define what an H1B is. H1B it's kind of the workhorse of the immigration program for allowing for foreign professionals to be employed in the United States. So it is a temporary visa. It's only good for up to 6 years, and an employer sponsors an H1B to a foreign national. It could be a foreign physician, it could be an architect, it could be a lawyer, a university professor, any of these professional positions. But it is an employer-specific type of a visa. So Frederickson and Byron sponsors someone for H1B. That individual can only work for Frederickson and Byron under the terms of that H1B. If they want to work somewhere else, that other employer needs to sponsor them for its own H1B. But it becomes a very commonly utilized, a very prevalent type of a visa classification that enables foreign professionals to work in the United States. Now, from your standpoint, from the standpoint of an employer, there are 2 types of H1B recruitment situations, and it's extremely important to understand. There is one type of recruitment in which when you sponsor someone for an H1B, you are making your sponsorship subject to the H1B quota, which I'll talk about in the next slide. So that means that the recruitment falls within a numerically limited allotment of H1B numbers. There's a second type of H1B sponsorship in which the employer can file the H1B sponsorship exempted from the quota, the H1B quota. So whereas the first type, a filing under a cap subject or quota subject type of a situation, means that you're struggling to make sure that there is an H1B visa number available, and therefore you can only file at certain times of the year when H1B visa numbers are available. The second type of a recruitment, which of the cap exempt, an employer could sponsor the foreign national at any point of time in the year. So at the very beginning, you need to figure out, are you filing and sponsoring someone who is subject to the cap, H1B cap, or exempted from it? So let's talk about the H1B cap for a second. It is a miserable situation, to say the least. In the U.S. immigration system, there are 65,000 H1B visa numbers are available within the U.S. immigration system. There's a supplement of 20,000 additional numbers for foreign nationals who hold advanced degrees, meaning master's degree or above, from U.S. universities. Okay, but the basic rule is there are 65,000 H-1B visa numbers in the U.S. system. The application period opens April 1. So you have anytime you have an H-1B sponsorship situation that is subject to the cap, an employer needs to prepare itself in order to file the H-1B sponsorship promptly on April 1. The problem becomes that there are historically far more H-1B petitions filed than there are H-1B visa numbers available. So last fiscal year, you had 233,000 H-1B sponsorships filed, chasing after the 65,000 numbers and in some instances the 20,000 supplement. So the chances based on last fiscal year of success is about 1 in 4. You enter a lottery if you're subject to the H-1B quota system. And at least based on where the economy is, what we perceive as employer demand, we'll probably face a similar situation this year as well. So the issue then becomes who is subject to the cap and who is exempt from the cap. Well, I've got great news for you, and that is anytime you get a J1 waiver under the Conrad Program or under the sponsorship of a government agency, any clinical physician getting a waiver is exempted from the H1B quota. So by virtue of the fact that you sponsor a physician under the Conrad Program, that not only obligates you to sponsor that physician for 3 years and obligates the physician to work for the employer at least 3 years, but it also removes that sponsorship from the H1B quota. That is enormously important, absolutely enormously important, in order to circumvent the constrictions from the H1B quota. In addition, if you're a university employer, or if you are certain nonprofit and university affiliated entities, you can also pick up an exemption from the H1B quota. Again, that's extraordinarily important. Many H1B extensions are also exempted from the quota, provided that at some point the physician was initially counted against the H1B quota. So once you're counted against the quota within the last 6 years, you're exempted from being recounted against the quota. So, and there are a couple other situations that would exempt an H1B sponsorship from the quota. But my only point is you've got to go through the analysis very rigorously, because if you're subject to the quota, you've got to, number one, file the H1B sponsorship promptly on April 1, and number two, bear the uncertainty that the case will not be picked up under the lottery system. So it's quite a disincentive. And so conversely, if you're not exempt from the quota, you are subject to it. And so all other H1B sponsorships are subject to the quota. So my only point is that in most instances, not all instances, but in most instances, you're going to start off an employment relationship with an IMG under an H1B sponsorship situation. And you've got to come to terms very early in the analysis and very early in the recruitment cycle with the salient question of, is this case subject to the H1B quota or is it exempt? Okay, we're going to move on. And again, I'm going to drive the conversation to permanent residence. And before kind of talking about the two basic strategies that are mainly utilized, I just want to kind of go back to a premise that I had initially stated in my opening remarks, and that is, in the back of every physician's mind, not every, but the vast majority of IMG's mind is, will the employer work with me to get permanent residence? That's kind of the ultimate objective of many foreign nationals, and in particular foreign physicians. So to the extent you feel comfortable and committed, or feel that you're in a highly competitive recruitment situation, you probably want to build in not just a discussion and possibly a commitment to sponsorship of permanent residence, but you want to kind of build in some type of timeline under which the parties agree to pursue permanent residence status. Now, there are two basic ways to get permanent residence status. One, under the slide, is called a perm labor certification application, and the second is a national interest waiver. I don't intend to speak to the details, but I do want to talk about the basic objectives and the basic theories of each of these sponsorship alternatives and how they can be used, and I think how you need to consider these two alternatives. For perm labor certification application, that is a process that requires the employer essentially to go through a 4-stage sponsorship process. But it really relies on the employer's agreement to recruit, to advertise in a manner that is recognized as being valid for immigration purposes by the U.S. Department of Labor. And so what it really requires is the employer to show that if it hires the foreign national, if an employer sponsors a foreign national or the IMG for permanent resident status, the acquisition of permanent residence will not harm the U.S. labor market, either by, number one, taking a job away from a fully qualified U.S. physician, or number two, by depressing the wages of similarly employed physicians within the local area. So there's a great deal of government oversight, and there's a great deal of actions that the employer needs to take, essentially in order to show that if the IMG acquires permanent residence, they won't harm other physicians, other domestic physicians who may want the job or depress the wages of of similarly employed physicians within the area. An alternative way to permanent residence is called a national interest waiver, and this type of filing procedure can only be utilized if the physician is physically working in a designated medically underserved area. So this works only for placements within HIPSAs, MUAs, MUPs, federally designated medically underserved areas. One of the things is that if the physician goes through a national interest waiver process, they need to work for 5 years within a designated medically underserved area in order to actually attain permanent resident status. So again, you've got an element of retention. Now, there's no one right or one wrong way in terms of how you sponsor someone for permanent residence. As a general observation, which obviously has many exceptions, physicians in their own right would prefer to go through the perm labor certification process because they're not obligated to commit to the employer for a 5-year period of time. But there is some downside strategically, tactically, and frankly empirically to that approach. It doesn't, again, fit for everyone. So, for example, one of the main advantages to a national interest waiver approach is that whereas under a perm process, you can take the preparatory steps for permanent residence at any time, but the physician, if the physician has a Conrad waiver, the physician cannot file the final request for permanent residence until he or she has completed the 3-year H1B service obligation. Okay? One of the consequences of that is that the physician's spouse, in many instances, will hold H4 status, which largely does not allow for employment, although there's been some relaxation. But the fact is that for family unity purposes, for family employment purposes, the dependents are placed at a disadvantage through a perm strategy approach, whereas a national interest waiver can be accomplished at any time, and unless the physician is from India or China, then as a corollary to the filing of a national interest waiver, the dependent spouse can get travel permission, can get employment authorization, even as the physician is working through the 3-year H1B obligation. I just want to address very briefly the situation pertaining largely to Indian physicians. India is the largest single provider of physicians to the United States. So I think the figure, it's something like 36% of all IMGs are from India. In the U.S. immigration system, there's a quota. We only allow a limited number of individuals to get permanent residence every year, and even within that, we have a limit of a per country limit. So only 7% of the given quota allotment can be can permanent residence be issued to any single country. Well, given the large population of India, given the large educated population of India, the Indian quota that is normally used for physicians, it's called the second preference, historically has been grossly backlogged. So, for example, a case for permanent residence can, for a foreign national from any country other than China or India, at present, normally can be accomplished in roughly about an 18-month period of time. And even that somewhat, in many instances, it can be less. That same case, because of the quota, at present, there's a 10-year waiting period for natives of India. Same case, same merits, same contribution to the United States, but because of the quota, the physician remains bereft of permanent residence for right now 10 years. And the backlog varies over time. I think in November the backlog goes down to about 7 years. But my point is there's a substantial backlog. Now, from an employer's standpoint, arguably that's not terribly bad. I mean, again, it goes to this idea of retention. You until the physician gets permanent residence, they may have certain substantial restrictions on their employment mobility in the United States. But my point becomes that from your Indian physicians, you will experience, in general, significant pressures to get a case going early for permanent residence, to explain and commit to permanent residence early in the process, because, again, they're going to be looking at a substantial period of time until they can get permanent residence. And conversely, you're, in many instances, are going to have the benefit of that physician's services until he or she can attain permanent resident status. Simply one final word on the, as my grandmother would say, the mishigas of the quota system affecting Indians, and that is, fortunately, as of this past May, there are certain situations where at least the dependent spouse, the H4 spouse, can get an employment card if the principal alien, if the IMG has gone halfway, has basically achieved what's known as the approval of the immigrant visa petition, that has taken the initial steps moving toward permanent resident status, at least the spouse will get employment authorization, which creates some level of stability and hopefully family harmony as well. Okay, in our waning couple minutes, and I know we have a couple questions, I just want to say that when, no one affirmatively goes out and says, I want to hire an IMG. That's just not how the system works, and probably it's not how the system should work. But there are going to be compelling circumstances that will lead employers to recruit and hire foreign physicians. And in those situations, again, you're going to face the exact same situation as you do with any other physician recruitment. It's competitive. There's a limited number of providers. There are wide ranges of opportunities, and therefore, the whole nature of this program is to suggest very strongly and very in no uncertain terms to regard immigration as another opportunity to make yourself into a competitive recruitment. Build immigration into your recruitment program, which basically means communicating a commitment, an understanding to the immigration welfare of the IMG candidate, to understand that the IMG candidate in many instances desires not only a good job, but immigration stability in order to live and practice medicine in the United States. Okay.
Thank you, everyone. We're going to, at this point, come to questions. For those who still have questions, please put them in your chat box, and we will get to them. Due to my voice, I will try to read these, and I will let Bob answer them. Bob, our first question is, are other healthcare providers, such as dentists, included in IMG definition? Yeah,
a great question. The answer is IMG really, as a term of art, refers only to physicians. I mean, there's certainly immigration needs and immigration programs for dentists. So a dentist could get permanent residence under a perm labor certification application. Dentists are certainly a profession that qualifies for H1B entitlement, but dentists do not have J1 obligations, do not have two-year home residence obligations. Also, they don't have national interest waiver opportunities. So, dentists have immigration needs, but they would be somewhat separate and distinct from the provisions related to physicians.
This is a very interesting question. How does this change if, and this is going back to our discussion of waivers, if a physician pursues a persecution waiver and receives temporary protected status within the first year of an employer obtaining a waiver and an H-1B?
Okay, temporary protected status is a status granted by the U.S. government to certain foreign nationals who are experiencing or would experience hardship or persecution back in their home country, and so it's an ability to stay in the United States and work. Even if a physician gets TPS, they still, that's a temporary immigration status. So they would still have ultimately a two-year home residence obligation, assuming that TPS is lifted. So it would certainly be very appropriate for that physician to pursue a waiver. Now, our discussion focused mainly on waivers conducted through the Conrad Program or through immigration or through a government agency. And those type of waivers say once you get the waiver, you need to have 3 years in H1B status, and it's employer driven. There is another type of a waiver, which we had one slide, and that's a persecution waiver, which says the physician, the foreign national, is seeking a waiver because he or she would face persecution back in the home country. That does not involve a residual 3-year H-1B obligation, and they could go straight to permanent resident status. So I think to answer the question, it is perfectly allowable to be in TPS and still pursue a waiver. In fact, you're going to need to at some point. And depending on how you structure the waiver, you're either going to need to go into H-1B, or perhaps through persecution or hardship, you could go straight to permanent resident status.
And here's a great follow-up to the question. So this doctor, what happened is sounds like the employer sponsored them under a Conrad program, obtained an H-1B. The physician was unhappy and got TPS and is now leaving the organization. And what this means is TPS is an entirely separate process, which means they are now have temporary work authorization. But it doesn't mean they've now subjected themselves again to that 2-year residence requirement, which means that doctor is not going to be able to adjust status to become a green card holder unless they take care of that waiver. And maybe that's why they're pursuing persecution, but it did give them, per se, the right to leave the employer to go someplace else because TPS is unrestricted. It provides employment authorization to do anything, any type of work. But it doesn't give them the same path to a green card that they had on working for this employer. And it's a separate provision. It's going to be very limited. I think there's only about 8 countries that are currently designated. So it's a unique situation, but unfortunately it would allow the doctor to leave. And you would basically withdraw your H-1B once they've left and notify the state that they've left, so that number may be able to be recaptured by someone else or you at a later date. This next question said, what is the first step for U.S. recruiters when considering IMGs currently in their home countries? What do employers, recruiters have to look out for?
Yeah, that's a great question. I think that the first thing, particularly if someone's in a foreign country, is forget about immigration. Are they a viable candidate for practicing medicine in the United States? Can they... the United States is very restrictive in terms of what credentials are required in order to gain state licensure. So the first thing is really to inventory the credentialing of the foreign physicians. Have they trained at an accredited institution, an ACGME accredited program? Have they passed the USMLEs? Are they qualified for a state license? Do all of those kind of preliminary things in terms of are they qualified to practice medicine? If so, then you start moving into the immigration sphere, and probably the the two issues that I would think would be most salient would be, number one, are they still working through a 2-year home residence obligation? Do they have any obligations there? Number two, if not, if you sponsor them for an H1B, are you going to be subject to the quota or not? Again, that's one of the key issues we discussed. And number three, what's your timeline? When do you need them? And can immigration accommodate both your and the physician's timeline?
I also want to add, just for an H-1B, it also requires a state license to practice medicine. So if the physician is overseas, there may be a bit of delay as well in making sure they can qualify for the license before you pursue the H-1B. And I'll just let you read it.
Okay. I've been handed a sheet of paper. Question becomes, what is the status of a physician whose H-1B expired and they're from India and are waiting for their permanent resident? Basically, and again, we're going to be, would want to do a more thorough consultation. But look, if the H-1B expires, they become resident in the United States without authorization or illegally. So this really underscores the need that as a foreign national, and it's more pronounced in India, is waiting for availability of this immigrant visa number under the U.S. quota system, they need to maintain their underlying non-immigrant status, normally H-1B, and if the H-1B lapses, then so does their immigration status, the legality of their residence in the United States. So that is really the reality of matters. Okay. Okay. I think we've run the duration of our allotted time. First of all, I just really want to compliment Deborah Schneider for her efforts and really her co-creation of this whole program. We hope very much this has been useful to you. It's certainly been a brief run through within 1 hour, but we hope we've planted some seeds and given some food for thought, not only in terms of the recruitment of foreign physicians, but again, making it part of your recruitment program. So thank you so much for your attention, and we look forward to hearing from you. Thank you so much. Bye-bye.